This morning to hear oral arguments in the case of State of Ohio versus Matthew J. Hartman. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and I will keep you apprised of the passage of time. We're being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We've read your briefs and we're ready to proceed when you are.
Thank you, Your Honor. Please the court, I'm Marilyn Kramer, representing appellant Matthew Hartman. I would like to reserve 5 minutes for rebuttal, please. I believe there was a book called Why Do Bad Things Happen to Good People? And one possible scenario applicable in this case, because this is a case where the defendant is innocent. One scenario is things happen when people do the wrong thing, when no one does the right thing. And every step of the way in this prosecution, the state has done things wrong, starting with an unlawful arrest, and then a deficient warrant that was never sworn to, had no supporting affidavit whatsoever, and was never presented to a judicial officer. Then there was a deficient indictment, and then the trial judge in the first trial, trial 1, erroneously held that the indictment would cure any errors in the arrest. So you would essentially never have any suppression of any evidence with that law, because you always have a suppression motion when there's an indictment first. So I'm sure that the state will make argument like it keeps doing, and was even in the order on appeal, that 2 prior juries convicted Matthew Hartman. That argument is essentially saying to have a presumption of guilt instead of a presumption of innocence. What they're overlooking is that both of those were reversed. So essentially, and on appeal, the appellate court is viewing the evidence in the light most favorable to the state. So on appeal, essentially, the court was applying a presumption of guilt, but in a proper manner. But even doing that, 2 appellate courts reversed the convictions, basically holding, in essence, inherently it's saying that there was insufficient evidence if you looked at.
And ma'am, if I may, I don't believe that either one of those appeals were overturned on sufficiency of the evidence.
That's correct, but sufficiency of the evidence was raised, as the newest judge held, Judge Cosgrove held, that we did raise it, but that became moot when it was reversed on other grounds. But what I'm saying is when they took all the evidence, we hear a lot in the news now about fake news, and well, in this case you have a lot of fake evidence. You have arguments of things that were not evidence, which led to the second reversal, arguments in closing argument by the state that stated things that were not even presented, and you also had arguments during questioning of witnesses. You essentially had all the things, all the prongs of the Doherty test, which is controlling. The state doesn't even address Doherty in its brief, but that's the controlling case in our case here.
Wasn't Doherty in this trial?
There yet, but all the 4 factors, all the prongs of Doherty are the same as here, and in Doherty, the state was prohibited from retrying the defendant because of that, those errors, that misconduct. Doherty said it could be dismissed with prejudice and would not be retried, which is what we're saying here. And we have even more misconduct and different things than that, but just under Doherty, the state did all of the things in the 4 prongs of Doherty, which we have in the brief. So that's why that would support or actually compel dismissing with prejudice here. So what the appellate courts did, like I say, they're viewing evidence favorable to the state, but they said that when you looked at all evidence, there's not enough real legitimate evidence or real evidence to convict Matthew Hartman. They could not rely on the judgment, so then it was for the verdict, so they were reversed. So more important than what 2 juries did when things were done improperly, it's important that those were reversed twice. Even looking at the evidence.
It wasn't because they couldn't rely on all the evidence. That wasn't the reason for either of the reversals.
But you still have to get the second prong of the analysis. It's not just were improper things done, was it harmless error or did it have an effect? So the appellate court is saying that they cannot say there was sufficient evidence. Even if you removed the improper things that were done, you could not say he would have been convicted anyway. So in a sense, that is just looking at the sufficiency of the evidence. Even aside from that, though, because we have more errors raised in this appeal, but I think that's sufficient. But even aside from that, you have pervasive and repetitive misconduct proceeding with the prosecution when you know there was an invalid arrest, when the homeowner comes and says, there's no burglary, he wrote to the judge himself, there's no burglary of my home, we've been friends for 20 years, and everyone keeps going forward with the case. And so the false evidence was not sufficient to, even with the things they were doing wrong, so then what they did was do deletions and changes to the transcripts. You had that deliberate, so what we're looking at is deliberate misconduct. United States versus Dinitz, the cases we rely on primarily, Doherty, Gardner, Adams, all of those show that they're violating, that would be triple jeopardy at this point, and also that because of the pervasive misconduct, there can't be any real law of the case. And we also, how could we retry him? The Sixth Amendment right under the Confrontation Clause, we have altered transcripts. And we presented 19 affidavits. The state had no affidavits, nothing of equal weight. All people who don't know each other didn't have any, things were different in the cases, but all of them are saying their transcripts were altered with the same court reporting service and the same Judge Collier. One was a different judge, but the same court reporting service. Transcripts altered, and those affected the outcome. The trial court we have now looked at it backwards. She's saying, well, these were all, she sort of sloughed off all the evidence and said, well, these are all people that have cases in the system. Well, of course, that's why you have, where else you can have someone with transcripts altered, except people who are here in court having transcripts. And then she said, well, they had adverse rulings. That's the point. Because of the alterations, they were denied fundamental fairness, as was Mr. Hartman, and they had rulings adverse to them because the changes were material. We're not talking typos.
Were any of those people, or did you ever contact any people who the case was not adverse to when they would have?
Well, some of them
that said it was wrong, but they got it right anyway.
Good question. Some of the people were just witnesses observing things in courtroom, corroborating what they observed, what other people said about the transcripts. I think at least 2 of the cases were civil cases. But why would all these different people, over a period of time, and then another thing that was not even looked at, like the present judge didn't even look at this, just said, well, sort of sloughed it off. But then also, no one has ever talked about the false billing by the same court reporter for the same judge. We've listed a number of cases, 6 to 8 cases, where she billed for hearings, being present to transcribe hearings, but when you look at the docket, there were no hearings on those dates in all those different cases. And all those false billings were signed off on by the same first trial judge with whom she's involved romantically. And one of those defendants was not even in Medina County. He was still incarcerated somewhere else. So there's no way there was a hearing here for him when he wasn't even brought to the county yet. I believe it might have been as long as a month later before he even came here. So you had that. So no one looked at that kind of thing going on.
Was it a month later or a month earlier?
He was not brought into Medina until after the date that she put in a billing slip for being at a hearing for him. But there couldn't have been because he wasn't even here yet. And like I say, the ones we listed, they're all in the brief, the specific case numbers. Those all are billings that you look at and the state's response on that was only to say, well, she is billing for preparing transcripts or things not in court, but that's not what the form is. It's a different thing for when you're typing up a transcript. This is her saying, I was in court for a hearing, and the judge signing off on it. Of course, the more...
Are you suggesting that the only time that she's able to bill for doing her work is when she's in the courtroom?
No, I'm saying it's a different process. And she's specifically stating, I was in court for a hearing and bills, and there wasn't. But of course, to us, they're all wrong, but the felony violation is changing transcripts and material alterations, and we have extensively briefed that in great detail. Obvious gaps in testimony, like the 18-minute gap in the Nixon tape, where I'm questioning witness on the arrest, and then the next sentence is Mr. Salisbury talking about the interrogation 8 hours later that we've never even mentioned yet, and the judge is saying that he has no more questions, but I was the one questioning. And then also we had affidavits from people that were submitted where Matthew Hartman's talking about the kind of gun that Matthew Hartman used to take for target shooting, and all of a sudden the answer doesn't go with the questioning. And
isn't there a process where you could correct the record?
We filed motions to correct the transcript. We did it over and over with detail. You have...
With the Court of Appeals, I'm talking
I don't know that all we did was raise it with them. I don't know that they would have the power to then say, go correct the transcript. Like I said, as Judge Calvin pointed out, they reversed on other things, but we certainly were. And the first appeal, even though Matthew Hartman, we requested that I be the appellate attorney, he said no, he doesn't like to appoint the same attorney. I thought nothing of it, and because there is a logic to wanting someone to take a fresh look at it, I'm essentially a federal prosecutor. I wanted him the best he could, so I said fine. So a different attorney handled the first appeal. He was not at the trial to know what was happening at the trial. And I know just in some discussions I had with him when I was talking about suppression and certain issues, he kept saying, I'm limited by the record. And I'm saying, of course I know. I've been a lawyer almost 40 years. I have 13 or 14 published opinions in the Sixth Circuit. So I know what you have for the appeal. But I don't know why he's saying that to me. But that's because he's looking at a transcript that I don't have. I don't get it till I'm doing the petition, the habeas petition, and then I'm seeing things. But the thing is, it's just like at a crime scene.
You have just under 5 minutes.
Thank you. It's just like a crime scene, they can't wipe up all the blood. We had filed so many motions and done questioning during the trial that there were still records of the things that were deleted in an indirect way. For example, at trial, and we were writing these things 13 months, 12 months before the transcripts are even done. But in trial, I asked, for example, Deputy Talatko, do you recall, when he changed his testimony at trial, I said, do you recall being asked these questions and giving these answers in a prior hearing? It was the suppression hearing. And he said, yes. And I'm saying the things that he was asked and what he answered, and he agreed to it. But then later, now we were on appeal, and they take 7 extensions of time to do the transcript. It's not in the transcript, but he had admitted in trial, that's what he said in the suppression hearing. And I had done a post-trial brief to try to correct errors at the trial court level, trying to get to the Court of Appeals. But the judge used that as a roadmap as to where to make the alterations in the transcript. Things that I said, these were the errors that occurred, this was a testimony, then they went back and took that out. But there were things referenced in motions, and like I say, referenced during the trial, that corroborated what we're saying happened that's now not in the transcript. And these are not typos, they're not something just a court reporter would know substantively to do. It's because she was coached where to make the changes.
And this is all relevant under your argument that Doherty controls these issues.
That shows some of the violations of Doherty, but also the cases we cited in our last assignment of error in the brief, the 3rd section, that talks about fraud and collusion that would void any law of the case.
You have 3 minutes.
Thank you, Your Honor.
Thank you and good morning, Your Honors. My name is Christopher Schroeder on behalf of the appellee of the state of Ohio in this case. We're asking this court to affirm the trial court's denial of Mr. Hartman's motion to dismiss on double jeopardy grounds. Your Honors, in regards to the numerous arguments that have been raised here this morning, the state has a number of responses, but please understand it's impossible for me to cover all of the arguments that have been put out on the record, and many of which I think are frankly unbriefed in the appellant's brief in this case. So I'm going to try to reframe the debate as to what we're talking about here this morning, which is double jeopardy. We're here because the Ohio Supreme Court held in the Anderson case 2 years ago that the denial of a motion to dismiss on double jeopardy grounds is a final appealable order. Double jeopardy is distinct from any other kind of a motion to dismiss in that regard. Motions to suppress are not final appealable orders. Motions to dismiss for prosecutorial misconduct are not final appealable orders. Motions to dismiss for defects in the indictment are not final appealable orders. What is final and appealable is the denial of a motion to dismiss specifically on double jeopardy grounds. So the sole issue that we are here on this morning is a double jeopardy analysis. Most of the arguments that have been made here regarding prosecutorial and judicial misconduct aren't relevant to a double jeopardy analysis. As an initial matter, I think all of those arguments are essentially moot because the remedy for prosecutorial or judicial misconduct where it exists would be the granting of a new trial. Matthew Hartman has received a new trial. And what the Ohio Supreme Court said in Liberatore is that the granting of a new trial wipes the slate clean. It restores the parties to the position they were in before the trial at which the error occurred. And that is the position that the parties are in now. Matthew Hartman has not been convicted. A trial date is pending at some point in the future. We don't know when. And at that trial, the jury will decide whether Mr. Hartman is guilty or innocent. So whether the previous prosecutor or any of the previous judges committed misconduct is not at issue in this case, because those people have been removed from this case. The case is proceeding in front of a new judge and a special prosecutor uninvolved in the previous misconduct, if there was any. With regard to the double jeopardy issue, I would point out that the Ohio Supreme Court held in State v. Keenan that a successful appeal of a conviction actually precludes a subsequent appeal on double jeopardy grounds. The only circumstance in which an appellate reversal will ever trigger a bar to a retrial on double jeopardy grounds is in the case of a sufficiency reversal, where this court holds that there's insufficient evidence to support a conviction. That's not what happened in this case. In the first appeal, Mr. Hartman didn't raise sufficiency as an argument at all. In the second appeal, he did raise it, and this court held that that was subject to res judicata. Because it hasn't been raised in the first appeal, the court couldn't consider it in the second appeal. So when we went back for pretrial proceedings in the third trial, the trial court found that it was bound by this court's mandate. And that's all that the court did in that regard. It said, I cannot consider this argument. The Ninth District has ruled it's subject to issue preclusion. I cannot and do not have jurisdiction to consider that argument. And in the Liberatore case, the Ohio Supreme Court held that retrial after an appellate reversal does not violate double jeopardy, even if prosecutorial misconduct was the reason for the reversal. This court has seen cases reversed for prosecutorial misconduct before. That doesn't bar the state from retrying the defendant. The only exception to that is the Dinitz case. And Dinitz talks about mistrials, where the prosecution goads the defense into moving for a mistrial, that deprives the defendant of his opportunity to go to a jury and possibly have the jury acquit him and end things right then and there. In that circumstance, if there's a showing that the state goaded the defendant improperly into seeking a mistrial, double jeopardy can bar retrial in that circumstance if it is the result of prosecutorial misconduct. But once again, that's not what happened here. There were no mistrials in this case. You had two convictions. You had two reversals by this court. First, reversal for erroneous admission of some evidence regarding the 911 call where the homeowner, Kim Layton, says that Matthew Hartman is bipolar and he has drug abuse issues. And the second reversal was for prosecutorial misconduct in closing arguments when the prosecutor essentially called defense counsel and the defendant liars multiple times during his closing. But those issues have been remedied by this court's reversal of both cases.
What about her contention, though, that when you're stating that they're in the same position as they were before trial, that he's got a third trial, fresh start, whatever, but if there's issue preclusion, there's things that were brought up in the first couple of appeals, how is he in the same position the third time around then?
Well, I would say that it's his choice what he raises in the first appeal or not. Whether he raises a sufficiency issue in this case, or in the first appeal rather, it has nothing to do with the prosecutorial misconduct arguments. That was a strategic decision that was made by counsel in the first appeal, who's a very experienced and very skilled lawyer, Mr. Dixon. I know him very, very well. And he chose not to raise that issue. And the only authority I think that the defense really has for this argument is the Doherty case, which is an unreported 5th District case from 1987. Your Honors, as I read the Doherty case, there is no Doherty test. Doherty is a very fact-specific opinion, and there's one part of this opinion, because I frankly didn't know what defense counsel was talking about as I read that case, but there's one part of that opinion where they have 4 numbered paragraphs. And I assume that's what counsel's is referring to when she says the Doherty test. That's not a test, and there's no written indication in that opinion that that's supposed to be applied in the future. Doherty is simply saying these are 4 factual findings that we make in this particular case. No one's ever cited that as this is the double jeopardy test that you apply going forward.
Was Doherty the case where the prosecutor questioned whether or not the person was at work?
Yes, the prosecutor asked a question and improperly put evidence before the jury, so the court reversed on that basis. But there's no Doherty test that you apply to future cases going forward. The test is Dinitz, which is about mistrials. With regard to the transcript issue, Your Honor, the allegation here is that the Medina County court reporter is engaged in some kind of a long-running conspiracy to systematically alter transcripts with the knowledge or even collusion of at least one member of the Court of Common Pleas here in Medina County. Initially, it's not clear to me why this would preclude a retrial on double jeopardy grounds, even if it were actually true. And I think that's true of a lot of the arguments that have been made here this morning. A lot of them are the prosecutor committed misconduct, the judge was biased, this evidence was improperly admitted. It's not clear, and there's no explanation in the briefs as to why that should preclude a third trial, where there won't be such misconduct, there won't be the improper admission of evidence. And as far as the transcripts go, the transcripts would only be relevant in the event that a witness was impeached by the defense using those transcripts. We, the state, can't use them. Or a witness was unavailable and we sought to take advantage of the prior testimony exception to the hearsay rule. We have, as I stand here today, no intention of doing that. There are only, I believe, 6 witnesses called in the second trial by the state of Ohio, most of whom are sheriff's deputies who are still available. And the only other one is Melissa Hartman, who is not cooperative with the state of Ohio, but is certainly available to testify. So we have no intention of relying on transcripts for any reason during the second trial. We intend to present live testimony. Live testimony is always what we as prosecutors prefer for the jury. We think that's better for the jury to gain an understanding of the case. So we don't intend to introduce the transcripts unless the defense intends to introduce them. They wouldn't be used at a third trial at all, because the jury generally shouldn't be told that this defendant went to trial twice previously and was convicted twice previously. That would be evidence we couldn't bring in. That would be prejudicial, because that would almost be asking the jury to rubber stamp a third conviction. 2 juries found him guilty. We're just asking you to do the same thing. With regard to the argument on the merits, I would simply say that this was primarily a credibility determination by the trial court. You had a number of people who submitted affidavits saying that they had found this to be true, but the problem is they're relying on their memories. They're saying, I was there in court, and some number of months or years later, I saw the transcript, and the transcript is different than what I remember happening. Memories are fallible. People forget things that happen. The court reporter is there typing in real time. It's difficult when you go back, even as a lawyer, when I go back over my own questioning of witnesses. There are things that I don't remember saying, or boy, did I really word it that way, that you see all the time. And it was primarily a credibility determination by the trial court, and the trial court found these witnesses were lacking in credibility. But even if she believed that they had credibility, even if there were irregularities in the transcript, the remedy for that would simply be to preclude the use of the transcripts at trial, which is an evidentiary liminal ruling that no one's ever asked the trial court to make here, or in the alternative, which something that has been done, would be to have new court reporters for the third trial. And I believe the trial court has ordered that the Cuyahoga County court reporters will be transcribing the third trial, because the trial is going to be held in Cuyahoga County at the old Lakeside Courthouse in front of a visiting judge, and there'll be a Cuyahoga County court reporter present for that. So I think the transcript issue is really not relevant to double jeopardy at all, and if it is relevant at all, it would be a criminal offense. It would be tampering with records, because the transcripts are government records, so that should be referred to a proper government authority, the FBI, the police, the sheriff's office, any number of people. It shouldn't be brought up in a criminal case as a tactical advantage to try and leverage a motion to dismiss. And with regards to the various prosecutorial misconduct arguments that have been made in this case, Your Honor, I mentioned this in my opening, but on pages 12 to 14 of the appellant's brief in this case, there's a series of prosecutorial misconduct arguments that are unbriefed. It simply says, see the briefs in the lower court below. This court's local rule 7B7 requires that each assignment of error be separately briefed so that I have an opportunity to respond, and so that this court can understand what those issues are. And this simply falls short of that. You can't say, see pages, whatever number it was, 3 to 68 of the briefs in the lower court, which were very extensive. With regards to the motion to suppress, Your Honor, which was raised and discussed in some detail by opposing counsel, Revised Code 293504 allows any police officer or law enforcement officer to arrest a suspect without a warrant where there's reasonable grounds to believe that a felony has been committed. In this case, police, I think it's the sheriff's actually gets the 911 call that there's a man with a gun at this address. In this case, the deputies respond. The 911 caller stays on the line with the homeowner. She gets significantly more information that he's in the house with a gun. Deputies respond, and they see this man, the defendant, outside the house with a gun talking to one of the homeowners. So they corroborated at least part of the story that this person was at that address, that he did have a gun. When they saw him getting on his ATV to leave, that's when they moved in and they arrested him. So you have probable cause in the form of the homeowner's statements on the 911 call that he was inside their house with a gun threatening people, and then you have partial corroboration of that when they get to the scene and they observe him at the address with a gun, which gave them probable cause to arrest without a warrant. And that's why the trial court denied the motion to suppress. And I'd also point out that the motion to suppress, like a lot of the arguments that we're dealing with here today, is not part of a double jeopardy analysis. The denial of a motion to suppress isn't a final appealable order, and I don't think it's right to say that because the double jeopardy issue is appealable, that we can then graft the motion to suppress onto the back of that. Because at that point, I think the Anderson exception kind of swallows the rule that nearly all of these things are not final appealable orders subject to interlocutory appeals before trial. But now, because we have this double jeopardy ruling in Anderson, that means you can bring all of your arguments and just label them as double jeopardy, and you get to appeal everything before trial.
Counsel, if you know, I can't recall, was the motion to suppress a assignment of error in the first appeal?
I believe it was not, and no, it was not. He raised the issue in his second appeal to this court in Hartman 2, and this court held in the second appeal that because the defendant did not raise that in his first appeal, it was subject to issue preclusion pursuant to law of the case. So it was not raised in the first appeal. And if there had been any merit to it, I think Mr. Dixon would have raised the issue. You obviously would raise a motion to suppress if you thought there was any merit to it at all. And whether there are errors in the transcript or not, you would still raise the argument. And I think as Judge Teodosio asked, there is a mechanism to correct errors in an appellate transcript. It's Appellate Rule 9. If you think there's something wrong in a transcript, the rules of appellate procedure prescribe a procedure for you to deal with that issue, which is you follow Appellate Rule 9, submit what you believe the corrections should be, and the court will address the issue from there. But this argument isn't being made for that purpose. It's being made to try and leverage a dismissal in this case, and I think that's improper. In closing, Your Honors, unless this court has further questions, because I know there are a lot of very diverse and unusual issues that are before the court, I would simply say that Anderson is a unique, limited exception. It should be confined to the double jeopardy issue, which should be confined to what the Supreme Court said in Dinitz and what the Ohio Supreme Court said in Keenan and Liberatore, which is that a successful appeal precludes a double jeopardy argument because it places the parties in the same position that they were prior to the wrongful conviction in the appellate reversal. Unless this court has any further questions, I will yield the balance of my time, and I will ask this court to affirm the trial court's decision and allow this case to proceed to a third trial so that a jury might determine some of these factual disputes that we've been talking about here this morning. Thank you.
Thank you. Attorney Kramer, you have 3 minutes.
Thank you, Your Honor. The fatal flaw in the entire state's argument is assuming that there's only one motion on appeal. He's talking about the double jeopardy motion, but we've also appealed, the notice of appeal, clearly also appealed our motion to dismiss on grounds of misconduct. So all of those issues are relevant because that's a ruling on appeal. And the lower court improperly ruled on that because she thought that that was an issue that was precluded. We are not put back in the same place as if nothing had ever happened before. We can't have a fresh start because we have corrupted transcripts. We can't cross-examine or use those transcripts.
How do you address State versus Keenan that states it's a fundamental long-settled principle that successful appeal of a conviction precludes a subsequent plea of double jeopardy? How do you square that with what your argument is?
Correct. Keenan was reversed for misconduct by the prosecutors, the County Prosecutor's Office, but the answer to your question is that that is not the only grounds. We cited that when there's judgment arrived at by fraud or collusion, then that's void ab initio. So that would open it up. We briefed that in our assignment of error. They're wrong to say that the only way it goes back is sufficiency of evidence. That's not true when you have fraud or collusion, that's the second motion that we're appealing that he's ignoring. They also ignore, we made the argument that you can't, even in the double jeopardy context, each alternative means has to be proved beyond a reasonable doubt. And we also had error in the second trial by them using alternative means that the first jury had acquitted Matthew Hartman on. The only thing they found him guilty of was burglary with intent to commit disorderly conduct. They expressly rejected, which was the entire state's case, that he went there for menacing or aggravated menacing or domestic violence or assault. They rejected all of those. They were told to circle, this is the brief, they were told to circle all of the intended crimes they thought he wanted to commit. and the only thing the jury chose, they rejected those, which was their entire argument at first trial, and only said disorderly conduct, which it clearly was not evidence for disorderly conduct because no one even mentioned disorderly conduct. That's something the state brought up when we're doing jury instructions, and they gave that as a choice, but those words never came up in the trial. So there certainly wasn't. So in the second trial, we argued that you can't try him on the ones he was acquitted on. He can only be tried for attempting to commit disorderly conduct. So the second,
Hang on for a second. What was he acquitted on? He was convicted of aggravated burglary, correct?
right, but they were told to circle what was the intent?
Underlying offense.
Underlying offense, and they were told, we have it in the brief, the quote the judge gave, circle the ones you feel he intended to
You're
commit.
talking about a
Yes.
instruction,
Special verdict to check which
jury
one.
instructions.
Correct. And then in the second trial, it was error to let them present those same ones, and they want to present them now in a third trial. And even worse, in the second trial, the judge did not have them specify what any intended crime was. He gave the instruction before the arguments were made, so the last things the jury heard were the prosecutor's wrong instruction to them that if one of them thought he intended to commit a crime, that was sufficient. So we don't even know which one they thought he intended to commit, and we don't know if it was only one juror.
Okay, and you're out of time with that.
Thank you, Your Honor.
very
We
much
ask
for your
that
presentations
it be dismissed, especially on the misconduct and the failure to prove forced death or deception, which we briefed. We ask that it be dismissed with prejudice, he not be retried, bond be returned, and I would point out to the court, he's now been released since 2013 and has had no violations whatsoever.
And thank you for your presentation today. The court will take a matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and at the Supreme Court.
Thank you.